Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is Circuits, Cargoes, and Cures. How does Singapore run competition and consumer protection? Joining me today is my co-host Subrata, Bhattacharjee. Hi, Subrata.
Hey, Anora, how are you?
Would you please do the honor to introduce our guest today?
I would love to do that. So we have today Loke Shiu Meng with us from the CCS. Now, let me just sort of talk a little bit about what the CCS sort of is about, because in addition, I think, to being Singapore's apex consumer and consumer protection agency, really in one of Asia's most competitive and I think dynamic economies, the CCS has really also emerged as a thought leader, at least I think, in Asian competition policy, and in fact has recently celebrated its 20th anniversary as an agency in Singapore. And so we are very lucky to have one of the senior representatives of the agency with us today. Shiu Meng is currently one of the assistant chief executives of the CCS. He oversees the legal and enforcement divisions of the agency. And indeed, prior to joining the CCS, he had a varied career in which he served in various capacities in the public service. He clerked for the Supreme Court. He held various positions in the Attorney General's chambers, the Ministry of Law, and the Ministry of Education. And prior to that, he had experience in private practice, working, of course, at the very well-known Singaporean firm of Raja and Tan. And so we're very lucky to have him here. I would also add that in addition, I guess, to his enforcement sort of work at the CCS, he's been very active in representing Singapore in sort of multilateral, multinational consumer protection forums, and is one of the key people, I think, behind the agency's enforcement agenda, both on the consumer protection side and on the competition side. So I think that is my wind up to this very impressive session I think that we've gotten. Anora, over to you.
Well, without much further ado, Shiu Meng, welcome to the program.
Thank you very much, Anora, and thanks very much for the introduction, Subrata. I'm very happy to be here.
So, Shiu Meng, Singapore's competition law regime has been enforced for roughly 2 decades, with enforcement against cartel and abuse of dominance since 2006, and the merger regime probably since 2007, if I remember correctly. So for the listeners who don't practice in Singapore, how would you describe the arc or evolution of enforcement from those earlier years to where CCS stands today?
Thanks for that question, Nora. I think that what I'd probably describe CCS's enforcement story really is one of steady and mature development from a competition enforcer to something more of a market regulator. So I think when we first started our journey into competition law in 2004, we were, of course, focused on first our enforcement priorities. I think we were busy setting up the shop and building up capability and as well as our credibility. But beyond that, I think over the 20 years, we have built up a solid body of decisional practices. And I think a number of our landmark decisions, such as the Chickens cartel, as well as the Grab-Uber merger, show our willingness to actually step forward to take interventions into the market, especially when we assess that there is indeed harm either to the competitive process in the market or to consumers. But I don't think that our story really focuses on just about cases that we've intervened in. I think it's also more about evolution. I think Subrata did mention that CCS also does take on the consumer protection function, and that's an evolution that we've seen over the years. I think in 2018, we first took on the fair trading function, and most recently last year, we took on functions that deal with product safety as well as legal metrology. So I think if I had to sort of describe the developments of the enforcement arc, it's really more of evolution in terms of the tools that we've had, the focuses that we've had, but at the same time, it all goes back to the same core principle, which is we're looking at how to keep markets competitive and how they continue to operate efficiently for the benefit of market players as well as for consumers.
So just to pick up on that, Shiu Meng, I understand we probably don't have time to sort of review perhaps the cumulative things in the agency's history that you may be most proud of, but I think it's fair to say that certainly in the last maybe 18 months, there have certainly been developments both on the policy side and on, I guess, the case side that the CCS has been quite active in. I wonder if you could sort of give us the highlights, I guess, maybe the things that you're most proud of the agencies doing in recent times.
Yeah, I mean, at the broadest level, I think we are very proud about the efforts that successive generations of CCS officers have really put in to establish CCS as a credible competition agency or market regulator within Singapore as well as within the region. But in more recent times, as you pointed out, I think a couple of developments have taken place. One of the things that we are quite proud about is the fact that we don't sit still. We're constantly evaluating our frameworks. We are tending to our garden. So we've actually amended our 2 sets of guidelines recently, or maybe more accurately, we've revised 1 set of guidelines. Those will be our merger review guidelines. And we've also introduced a new guideline to deal with fast-track procedures to move cases more quickly towards final resolution and also to manage the resources on our end. I think another major development that we've seen just over the past couple of weeks is the issuance of the very first High Court decision in Singapore touching on competition law. So I think that's a really important development for us because it does affirm a number of enforcement principles that CCS has adopted in our decisional practices, and at the same time also lends greater certainty to businesses and our market players in Singapore.
And so just to unpack that a little bit, especially because our audience may not be, I think, completely familiar with sort of both the merger process, but also even the settlement track on contentious cases. Let me ask you a little bit about the revised approach to mergers, at least in the guidance. My understanding is that you have sort of undertaken some measures in the guidance to maybe streamline that process in a way that's maybe consistent with ICN sort of guidance, especially in cases that are, shall we say, of not high substantive concern to the agency. And maybe you could just tell our audience a little bit about some of the highlights of that streamlining.
Sure. I think the thing that we have focused on is that our enforcement philosophy focuses on making sure that we do take targeted interventions in appropriate cases, but yet at the same time, we do not necessarily want to stand in the way of uncontentious transactions. So trying to strike that right balance means that we've actually taken the time to review our guidelines to make sure that in instances where there are mergers that have been assessed by us at what we call a phase 1 review, that's done fairly quickly. I think the idea as part of that review process is to really try and identify quickly if there are serious enough issues associated with the merger. And in those situations, if there are no serious issues, we will try our utmost to try and clear these mergers quickly. And at the same time, part of the review of the guidelines also introduced a certain higher threshold for CCS in the sense that if we go through our phase 1 review and we do identify issues, we will try to be clearer to the parties if we have to transit from a phase 1 preliminary review into a more targeted, more intense phase 2 review. I think just for a bit of contrast, in the past, when we moved from a phase 1 review into a phase 2 review, the threshold was that we were not able to identify a clear competition issue or clear the merger without any issues at all. We would move straight away into phase 2, but that doesn't give the merger parties a lot of clarity in terms of what exactly are the concerns that CCS has. So part of this new review process, the revised guidelines actually do require us, when we transit from a phase 1 into a phase 2 review, to be clearer to the parties, to say, look, these are the competition concerns that we do have with your merger, and that allows parties to then assess, is this merger something that they are going to press ahead with, and whether they should then start considering offering commitments to address those concerns, or whether they want to consider maybe abandoning the merger altogether. So it is really trying to strike that balance between moving ahead with rigorous assessment, at the same time giving enough clarity to businesses so they can decide for themselves how they want to take the merger forward.
So it's almost like a formal take stock meeting that you now have enshrined in the process.
Yes.
And also, have the guidelines also sort of changed the information requirements on parties that are notifying to the agency? Are there differences maybe between the information that you require in harder cases versus easier cases?
Well, I wouldn't say that it changes radically the information they require. I think the forms still remain largely the same. However, I think internally we are calibrating to make sure that at the preliminary phase 1 part of the review, we do not in a sense, inflict ourselves too much on the merger parties. I think we have to be quite targeted about the questions that we ask. It's really just to elicit whether or not there are genuine competition concerns. So we wouldn't apply a scorch the earth approach. I think we have to be quite calibrated about it. So that's something that we've tried to internally make adjustments to.
And would that be sort of fair to say it's really more of a triage-driven approach now, where you do try to sort of filter, you're really trying to filter your effort from the hard cases versus the ones that are not as difficult for you?
Yes, that's absolutely right.
Let me ask you now, just to also follow up on the second thing, or I guess the third thing that you said, which was this case. And I understand that that was an information exchange case involving warehouse operators, I think. And as I understand it, that was a litigated case in that the agency arrived at a decision on the inquiry. It went to one stage of litigation. There was a result. And then now you have a decision from the high court, I guess, that has reinstated your initial decision. Can you tell me a little bit about sort of the facts that sort of led to your challenge and sort of what the significance of the decision to the agency is?
Sure. I think, of course, right now there is still an ongoing potential for appeal. So I'll necessarily have to be a bit stingy with the facts. But what I can say is that as you rightly pointed out, it was a conduct involving various warehouse operators. I think one of the points which the parties took in the case was that the market shares, or their relative market shares, were fairly low. And therefore, if we did not appreciate or take into consideration the fact of those low market shares, then that had an impact on the economic context, and that had and consequently also whether or not it was appropriate for us in that case to classify the nature of the conduct as a by-object infringement. I think our position was that certainly market shares can be relevant, but they can't be the be-all and end-all. And certainly in certain instances where the behavior is patently clear that parties are attempting to undermine the process of competition, then there can be sufficient basis for us to find a by-object infringement, notwithstanding the fact that market shares might be low.
Wow. So at the end of this, you have a decision which helps stakeholders in Singapore sort of assess their position under the law, and that's a positive development.
Yes, indeed.
These are very helpful updates, and we already talked quite a bit about a merger, but let's just take a step back and maybe give our audience a little bit of a broad stroke, description of the framework of the merger enforcement and competition enforcement generally. So I understand Singapore's Competition Act is broadly modeled on the UK framework. Correct me if I'm wrong. And one additional, I guess, maybe different feature is that Singapore has a voluntary merger notification regime. So given those background, how would you describe the key features of Singapore's competition enforcement regime? And what are you thinking of potential changes or no changes at all from the voluntary to mandatory regime in terms of merger notification?
Yeah, thanks, Nora. Well, I think our regime, as you rightly pointed out, does borrow heavily from the UK model. But consequently, it also doesn't come as too much of a surprise to many of your audience and about the particular nuances about how we implement competition law in Singapore. There are, of course, the three traditional prohibitions that you find. The first prohibition, of course, against anti-competitive agreements and concerted practices. I think you have the second prohibition against abuse of dominance, and of course, the third prohibition, which relates more to merger control. So on the issue of merger control, you're right, we do operate a voluntary regime. But I think the important thing to note is that a voluntary regime doesn't necessarily mean that there's a passive regulator. I think precisely because you have a voluntary regime, it does call for a certain degree of proactiveness on the part of the regulator. And that's something that we've had to develop over time. I think it's really about trying to balance business costs as well as effective enforcement. We have over time tried to invest a bit more in terms of our market intelligence capabilities. We do actually expect parties to, first of all, do their own self-assessment as to whether or not a merger raises competition concerns. Of course, if there is doubt about that assessment, parties are free, together with their counsel, to write in to CCS for a decision. And then we will consider a merger as well as whether or not it can be cleared on the basis that there are no competition concerns or that there are sufficient commitments that are offered to address those competition concerns. But in instances where the parties decide not to notify us, And at the same time, CCS might actually pick up certain signals from the market that there may be competition concerns. I think we also go in to investigate the matter. If necessary, we will then take action to impose interim measures to preserve the status quo.
This is exactly sort of my follow-up question, but in fact, this is what I understand you did in 2024 in a reasonably high-profile transaction, yes?
Yes, yes. So I think you're referring to the Grab Delivery Hero proposed transaction. I think at that point in time, there was quite a bit of market chatter about whether or not that would happen. And sometimes you do see these kinds of speculations, making their rounds when there are parties who are exploring options. But I think in that case, when we did pick up on some of the chatter, we did actively reach out to the parties to understand what they were intending to do. And once we did receive some confirmation that, indeed they are exploring the possibility of entering into such a merger, and bearing in mind that these two were basically the largest platform operators at the point in time within the Singapore market, we felt that there was going to be a risk that if the merger did materialize, it would have a significant impact or substantial lessening of competition in Singapore. And that's why we moved quickly to impose our interim measures. I just want to be clear that the interim measures don't exactly prejudge the issue. They're really there to just preserve the status quo so that we can continue the assessment. And at the end of the day, if indeed we find that there are competition concerns, it's going to allow us to impose remedies that ultimately are going to be effective. So that's really the purpose of having those interim measures. So if you think about it, there are really two facets to this. I mentioned earlier that voluntary regimes are not necessarily bad, provided that they are supported by active or proactive market intelligence and interventions by regulators. But at the same time, we have to recognize that in certain markets, especially digital markets, they tend to move very quickly. And I think some of the developments can potentially have a great implication for the level of competition in the market. And that's why interim measures and proactive intervention by the competition regulator is going to be so important.
The question that I would have just to follow up on that, Shiu Meng, is that there are other jurisdictions in Asia Pac that have sort of like Australia notably that have moved from a voluntary system to a mandatory system. And I guess my question is whether you think that Singapore sees any reason to go down that road.
Yeah, I think that generally the voluntary regime has worked well for Singapore. We've also been able to get sufficient market intelligence, whether it's from market players, members of the public, sometimes even media and journalists. So coupled together with our interim measures powers, I think it's so far been working well for us.
If I can just follow up as well, more generally on sort of enforcement activity of the agency. Obviously, the CCS has really grown and developed over the 20 years of its existence, but I think it's fair to say that the CCS certainly has enhanced its enforcement activity. And I think, for example, in particular of the bid rigging cases that the agency has brought, as well as some of the consumer protection cases I've been reading about. What is driving, I guess, that perceived increase in activity?
Right. I do think, to be fair, there was a slight pause in terms of the intensity of our enforcement actions during the COVID period. So I think we did have to pause a bit on some of our activities. But I think since then, we've also been taking a number of investigations forward. But I think as many of your audience would appreciate, investigations into competition cases do tend to take quite a bit of time. There's a lot of evidence to work through. Complex theories of harm need to be explored. And so I think even if there is a perceived uptick in recent enforcement action, that's really the tail end of earlier investigations that we have also commenced. And these are basically just the cases working through the entire process and then eventually coming to fruition. I think the other area that I think also drives some of this behavior is I think the steer that we've gotten from our chief executive, Alvin. He also believes that there is a need for constant presence, enforcement presence by a regulator. Enforcement presence doesn't necessarily confine itself to just the taking of cases and the conclusion of one particular case, but the conclusion of that case can also send a signal to the rest of the industry that the competition regulator or the market authority is actually paying attention to developments. So I think he takes the view that it's important for there to be constant enforcement presence on our part. The third thing I can say about why there's been also a bit of an uptick has to do with the level of international cooperation that we've seen. I think we've also seen that whether it's in terms of leniency applications that are made to us, I think it's also because the councils who are coordinating in various jurisdictions have also seen it necessary to notify some of the conduct that applies to Singapore. So having that trust in our leniency framework and also the cooperation between not just international coordinating councils, but also Singapore councils actually does help contribute to that pipeline of cases that we see.
Talking about sending signals to the market, I think one of the signals that may have been sent and well received is that digital markets is an enforcement priority. But what does that look like more concretely? Are there any active investigations? Obviously, I'm not asking you to disclose that anything that you cannot disclose, but how does CCS approach platforms, for instance, given Singapore's position as a regional or global technology hub?
Yeah. So there are a number of aspects to this. I think the first is really to recognize that competition principles actually apply equally to the physical realm, to your traditional markets, as well as to digital markets. But of course, we recognize, and I think many competition regulators across the world also recognize that the nature of digital markets might be different simply because of aspects like the emphasis on data, network effects, tipping of markets, and so on and so forth. So I think that whilst the nature and some certain aspects of the market might differ, I think the principles, the competition principles that we apply ultimately remain the same. So we've taken a number of actions in the past involving digital markets. There were ride-hailing cases, and there were also cases involving food delivery services. You're right, I can't really talk about the actual cases they were pursuing, but I can say that there are some investigations that are afoot. In terms of Singapore's circumstances, I think it's true that we are in a somewhat interesting situation. Naturally, we are a small economy, but we are also a regional technology hub. And by virtue of that, what you do see are certain characteristics. For example, there are platforms that are operated not just by the huge international corporations that are present in Singapore, but you see regional platforms from the Asia Pac region, as well as our own homegrown platforms. So within the e-commerce digital space, there are quite a number of players within that market. And it does mean that our consumers have got greater choices in terms of whichever platforms they want to go with, or whatever products and offerings they can find online. But because we recognize that digital markets can tip, and they can tip fairly quickly, it does require a certain degree of vigilance on the part of the competition regulator, as well as also working with other government agencies that are responsible for other facets of the digital economy.
Thank you for that. Now let's talk a little bit about the other letter C in your name, which is consumer protection. I think CCS recently took on a significantly expanded consumer protection mandate, including perhaps the product safety and weight measures transferred over in July 2025. What does that consolidation mean for how the agency operates?
Well, I think that, like I mentioned earlier, it's really kind of that evolution of our general enforcement mandate. But it does still, at the end of the day, feed back into that wider policy remit, which is to ensure that the markets are functioning well and functioning effectively. So I think that it's not really, the transfer of those functions really wasn't focused entirely on the need for greater efficiency, although certainly efficiencies are reaped, but it actually allows for us to examine certain kinds of conduct and to look at it not just from one facet of competition law, but also looking at it from the consumer perspective. Because I think at the end of the day, we have to recognize that competition law as well as consumer protection law, be it fair trading, product safety, or legal metrology, these are all complementary principles. And I think having a good understanding about the types of harms that you might find in markets, whether they affect competition or whether they affect the way consumers behave on the market, actually helps CCS to be able to come up with more robust theories of harm. And our interventions can be a bit more targeted, because when we think about an intervention into perhaps a competition theory of harm, we are also keeping an eye on how certain remedies, if imposed, may also visit certain consequences when it comes to consumer rights and consumer benefits. So it allows for us to be a bit more holistic in terms of the way we enforce our different dates.
Shiu Meng, just for the non sort of Singaporean listeners, what is legal metrology?
Well, legal metrology effectively deals with instruments that measure weight and other kinds of units of measure. And the purpose of legal metrology is to ensure that if a business goes out and represents that it sells certain quantities of a product to a consumer based on a certain price, that the measurements that it uses to determine the eventual price is accurate.
Got it. So let me ask you just a couple more questions on sort of some of the consumer protection work that the agency has done. I did think it interesting that two of the recent cases or investigations that the agency had done involved sort of areas that have been of interest to consumer protection agencies around the world. One of which is dark patterns case, which I understand that you guys had brought. And the second, I think, was fake reviews. And so perhaps maybe you can just give our listeners a bit of background on those two cases.
Right. I think there are a number of aspects to dark patterns. I think that the difficulty about dark patterns is that they are something that is, you can almost see it as the tip of the iceberg. You don't really realize that you're the victim of a dark pattern simply because it manipulates you to make a certain consumer choice which you otherwise wouldn't have ordinarily have made. So the kinds of harms that you see arising out of dark patterns are not so obvious to the consumer, and therefore it also means that the complaints that you receive will be very muted. So I think when we took some of these cases, whether it's involving fake reviews that were placed by a business online, or whether it had to do with other kinds of dark patterns, for example, sneaking into basket, where a business actually adds products which the consumer never asked for at the checkout counter before the consumer actually proceeds to make payments. I think these were cases that we took in order to highlight the manipulative nature of some of these online, call it choice architecture decisions that were taken by businesses. We felt that it was important to take these cases simply because there was insufficient awareness within the market, especially amongst consumers, about the way in which they are being manipulated. So like I went back to my earlier comment, I think it's about signaling. We also take these cases because we need to signal to businesses that some of these kinds of behaviors are no-fly zones. And at the same time, we want to be able to use these as examples to highlight to consumers that they really do need to exercise more care. Imagine that you are in a supermarket, a physical supermarket, and you're going about making your purchases. Would you, for any minute, find it acceptable if you went to the cashier to make your payments, and before the cashier actually asked you for your money, the cashier inserted groceries into your basket which you never asked for? Would that even be acceptable if we were in a brick and mortar situation? Would you have found it acceptable if you went to make payment at a self-payment kiosk and the business or the supermarket removed the function to allow you to take out items which you've had a second thought and think, maybe I don't want to purchase it? And it's forcing you to basically proceed with the purchase. Right? So some of these examples, I think when you think about them in a physical context, we will find this manifestly unacceptable. But strangely enough, we do see similar kinds of behavior happening in the online sphere. And for whatever reason, maybe it's because of the level of awareness, consumers don't seem to pick up on how harmful these kinds of behaviors are. So it's really important for us to be able to drive home the point, and really enforcement action allows us to do that.
And is your decision to sort of examine these matters triggered by consumer complaints, or do you have the ability to go into sort of a sector and decide this is an area of concern that you want to examine further?
I think it's a mix. There are instances where we've seen, and I think going back to my earlier point about how sometimes these cases only represent the tip of an iceberg, we do have muted complaints coming out of from certain consumer segments. But by and large, I think we've also had to do a fair bit of our own market monitoring, having our officers actually go down to businesses to observe how they are actually going about structuring their websites, and then from there deciding for ourselves which is an appropriate case for intervention.
That's very helpful, Shumi. Since we're the American Bar Association, we're facing a global audience. We naturally want to think about everything we talk about on a global scale. So perhaps let's talk about a little bit about Singapore's place in global competition. So Perhaps it's fair to say Singapore is a city-state running an open and trade-dependent economy, which is in a world of trade wars and even more fragmented supply chains. So the exposure of Singapore as such an economy is more acute than ever. So how does that shape CCS priorities, perhaps, and how does it create tensions, like in terms of things that you have to enforce over that like larger jurisdictions or other jurisdictions would not face?
Right. I think what you just highlighted are the realities of the day, and they are things which are constantly on our minds as a market regulator. The reality is that enforcement for the sake of enforcement is really not the goal here. I think from CCS's perspective, what we see competition policy doing is it's a vital part of the entire economic framework that is meant to ensure that markets operate properly, consumers are not detrimented. At the end of the day, it also contributes towards Singapore's resilience as an economy and as a country. So our philosophy about competition law and also consumer protection law is not really just about enforcement for the sake of it. We look at targeted interventions where the harm is great, but at the same time, our philosophy has been to use other kinds of tools, looking back into our actual toolkit to see whether there are solutions or effective remedies that we can implement, not really through enforcement, but through other means as well. But going back to your comment about Singapore as a economy, I think there are a number of things that also Singapore has to take into account. Number one, we are a small country. We are a small economy. The reality is that when you have a small economy, there are certain characteristics of that economy that you do need to take into account when you look at competition enforcement and competition policy. Small economies means that businesses, in order to survive, do need to achieve a certain degree of economies of scale. They do need to reach that state in order to be able to effectively compete, not just within the domestic market, but probably also within a wider regional market or even an international one. So we cannot necessarily adopt certain principles or positions which you find in other larger economies when it comes to competition enforcement wholesale and just apply them into the Singapore context. I think we have to be quite pragmatic about it. So we are usually looking at questions of whether or not there is going to be ultimately a benefit to the intervention by ensuring that the market still continues to perform in an effective, open, and efficient way. And we have to be quite selective about the types of cases that we do take.
Now, Shiu Meng, I had mentioned this a little bit in my intro, but I want to sort of go back to involvement with international sort of initiatives. And of course, I understand that you've been quite heavily involved on behalf of Singapore in ASEAN activities in the consumer protection and competition space. So I wanted to ask you a little bit about sort of the CCS's role, participation in ASEAN. Of course, I understand that the agency hosted the 11th competition conference in September 2025. And after that, that then resulted, I guess, in that framework agreement on competition. And for the benefit of our audience, can you tell us a little bit about how you view the agency's role in ASEAN and sort of the implications, I guess, of that framework agreement?
Right. I think maybe as a preliminary point, it's kind of important to remember that competition policy and enforcement is a fairly young and new regime that you find within the ASEAN family of countries. I think if you cast your mind back to about maybe 20 years ago, there weren't many ASEAN countries or ASEAN member states that had very developed competition law regimes. So I think the past 20 years has certainly seen very interesting developments in terms of the flourishing of competition practice within the ASEAN region. We also, of course, naturally have to accept that there will be various ASEAN member states who are at different levels of development. But I think by and large, the trajectory is something that's very hopeful for the region. When it comes to Singapore's role, I think we've seen ourselves as really trying our best to support the development of competition law and policy thinking within the ASEAN region. As you rightly pointed out, we do support some of these conferences. We host some of these conferences, but at the same time, we participate in maybe capacity building and exchange of ideas. We don't really see it as a goal of Singapore to impose its own competition worldview on other ASEAN member states, but we do like to see ourselves as contributing to part of that conversation. And to the extent that we are able to reach some consensus on competition principles, I think that is always effective and desirable when you talk about ASEAN community as an economic trading bloc. I think that we've actually tried our best to participate in, for example, peer reviews with other ASEAN member states. We've given them input, and we also do send our officers from time to time to have conversations with fellow ASEAN member states in terms of how Singapore views competition law, and also to develop some of the thinking in conjunction with also support and assistance from other regulators from other parts of the world.
This has been a very helpful conversation, and I almost hate that we come to this almost the end, but let me just squeeze in maybe one more substantive question, which is, I think you mentioned already, like, Singapore cannot adopt competition or consumer protection regimes from like larger jurisdictions wholesale, and you talked about CCS being pragmatic, and I think CCS has also talked about being bolder and nimbler. So what does that mean in practice? What should the global practitioners expect from Singapore and from CCS over the next few years?
Right. So I think the comment about being bolder and nimbler, it shouldn't be understood as a pivot away from what our positions have been in the past. I think it's really about reminding ourselves that we do need to look at our competition toolkit. We need to, as I mentioned earlier, tend to our garden. And we do need to think about whether or not enforcement necessarily is always the way to go. Well, I think while enforcement certainly is going to continue to be an important aspect of the work that CCS does as a market regulator, I think the other part of it is really trying to find other tools that we have at our disposal to help to further development of competition and to ensure that markets behave efficiently. So I'll give you an example. I think in recent time, we have also thought about how our market study powers do not necessarily need to be applied simply as an enforcement mechanism, but that we've actually been able in appropriate instances to use our market study powers to derive insights into the competition dynamics within certain markets. And using those insights, we share it with other government regulators who happen to look at those markets as well, and work with them to frame policies and interventions which address whatever their regulatory concerns might be, but yet at the same time maximize the potential for open, effective competition within the market itself. So we see this as some kind of synergy between not just competition policy and our role as not just an enforcer, but also an advisor to the government, but at the same time also trying to see how it can work well with industrial policy to a certain degree.
This has been hugely helpful. And as I signaled, as we come towards the end of the program, we also have somewhat a silly but personal segment so that our audience would have an opportunity to learn about you as a person. So just to shift gear a little bit, could you tell us a little bit about yourself that people would not know about you if they had only known you or worked with you professionally?
I think maybe appearances notwithstanding, there was a time when I used to practice martial arts quite a fair bit. I do have a black belt in Taekwondo. I also practiced judo, and I think probably from my experience in judo, I did extract certain key principles which do apply also in the competition sphere, which is that sometimes you may have the most effective tools as a competitor, but at the end of the day, size does matter. So there is really that kind of experience I've had when I was actually practicing martial arts. But I think since then, I've left those days behind. I do experience more joy nowadays actually taking hikes with my wife in many of the different parks that the government has had to spruce up since the COVID pandemic took place. So those, I think, are the things which I tend to find joy and also happiness in doing.
So turn to the end, almost like a bonus to ourselves so that we get another chance to learn about you. We go to a segment called A Curious Hat.
And now it's time for the Curious Hat.
Well, always like to remind people that is neither Anora's voice or my voice. So my question for you, Shiu Meng, follows up on that. And that is, if we have so many audience members who no doubt either have been to Singapore or like to go, if they went and if they wanted to do one of those hikes, which is the one that you would recommend?
I think one of the first places people will talk about will be Gardens by the Bay. And I think when you look at all the YouTube videos that you find about Singapore, it always features very strongly. But I think that we have many other parks that are also very well done up. So I think one of the other places that I would strongly recommend would be our botanical gardens. But quite apart from that, there are also other parks, like for example, our Japanese gardens and our Chinese gardens, which are located somewhere in Jurong, a bit further to the west of Singapore, away from more of the touristy spots. But if you do go there, I think you will have lovely vistas, less people, which always adds to the quiet enjoyment. And it's something that I would recommend to anybody who visits Singapore.
There you go.
As we learned from the movie Crazy Rich Asians, there must be some secretive and beautiful gardens out there in existence. Perhaps you can lead us to one of those.
If you ever find yourself coming through Singapore, I'd be happy to do that.
Thank you so much, Shiu Meng. That was really, really great. And thank you for the travel tip.
Most welcome.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.